The Supreme Court just made a major move that has everyone talking. They issued an emergency order that's bringing the Second Amendment battle back to center stage, and this decision could change everything for gun owners across the United States. For a long time now, various states have been testing the boundaries of what the Supreme Court previously ruled about Americans' rights to own and carry firearms. These states have created laws that make it incredibly difficult, time-consuming, and sometimes practically impossible for ordinary people to protect themselves with firearms. This happened even after the Bruin ruling clearly stated that these rights are constitutionally protected. But the Supreme Court is getting involved again, and this time they're not being subtle about it. This isn't just a gentle nudge or a quiet reminder to the states. This is a serious warning. The reason this matters so much is because this emergency order doesn't just affect a single lawsuit or one particular state. This has the potential to completely transform the legal situation for gun owners throughout the entire country. Before we get into the details, I need you to do something really quick. Smash that like button right now if you care about protecting your Second Amendment rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. Let's dive into what actually happened and why this emergency order is such a big deal for anyone who cares about gun rights. The Supreme Court surprised legal experts and state government officials by issuing an emergency order to review a massive Second Amendment case. This case could potentially overturn numerous restrictive gun laws that states passed specifically to work around the Bruin decision. The lawsuit causing all this attention is called Woolford v. Lopez, and it's coming from Hawaii. This case is challenging new concealed carry laws that Hawaii passed almost right after the Bruin ruling came down. Many people view these laws as Hawaii openly defying what the Supreme Court had decided. Hawaii's law works similarly to laws in California, New York, and New Jersey. These laws were written in a way that makes it almost impossible for regular, everyday citizens to carry a gun in public, even when they have the proper permit to do so. When the Supreme Court issued the Bruin decision, they made something very clear. The Second Amendment protects people's right to carry guns outside their homes for self-defense purposes, and states cannot create subjective requirements or put excessive limitations on this right. But Hawaii and several other states responded by creating what critics are calling vampire laws or catch-all bans. These laws basically turned the entire concept of public carry completely upside down. Rather than operating under the assumption that someone with a valid permit could carry their firearm unless a property owner specifically said they couldn't, these new state laws made it illegal to carry a gun anywhere that didn't have a sign explicitly giving permission. Just think about how that actually works in practice. Under the law that Hawaii created, even if a business is open to everyone, like a supermarket, a gas station, or a restaurant, you could face criminal charges just for walking inside with your concealed weapon unless there's a posted sign saying guns are allowed. That's exactly what the Woolford lawsuit is challenging, and that's why this emergency order from the Supreme Court matters so much. Now here's where the situation gets really fascinating. The lower courts in Hawaii initially decided that the state's restrictions probably did violate the Second Amendment. A federal judge even issued what's called a preliminary injunction, essentially saying the law was too sweeping and violated the Constitution. But then the state appealed that decision, and the Ninth Circuit got involved. That's when everything became confusing. The Ninth Circuit decided to uphold Hawaii's restrictions. Their reasoning was that Hawaii's law was actually more lenient than other states' laws because Hawaii let property owners give either written permission or verbal permission for people to carry guns. But at the exact same time, that same circuit court struck down California's law, which was nearly identical to Hawaii's, saying it violated the Second Amendment. So you ended up with two completely contradictory rulings about essentially the same kind of law, and both rulings came from the same circuit court. This contradiction is a major reason why the Supreme Court decided to get involved. When the case made its way up to the Supreme Court, Hawaii tried to change its position. They argued that the case wasn't ready for the Supreme Court to review yet, that more evidence needed to be collected, and that the court should send it back down to the lower courts. But here's what makes this interesting. When Hawaii was arguing before the Ninth Circuit, they had already told those judges that there wasn't anything else that needed to be developed and no additional evidence that needed to be gathered. They specifically said it was purely a question of law. The Supreme Court noticed this contradiction, and that's probably a major reason why they agreed to this emergency review. In simpler terms, Hawaii trapped itself. They said one thing to one court and then said something completely different to another court. The Supreme Court caught them doing this. The court's emergency order focuses the review on one very specific question. The question is whether Hawaii's law violates the Second Amendment by automatically assuming that all private property that's open to the public is off limits for lawful concealed carry unless the property owner gives specific permission. This means the court is directly examining these catch-all bans that have appeared in multiple states following the Bruin decision. This is absolutely huge because whatever the court decides about this issue won't only apply to Hawaii. This could establish a precedent that applies across the entire nation and impacts laws in California, New York, New Jersey, and other states. And this is where the ripple effects start happening. Almost as soon as the Supreme Court issued this order, legal teams all over the country started filing motions in related cases. They're asking courts to pause or reconsider their proceedings until the Woolford decision gets announced. Why would they do this? Because everyone understands that this ruling is going to define exactly how far states can go when restricting concealed carry. It would be pointless and expensive to keep fighting these other cases before the Supreme Court establishes what the standard actually is. Once the Woolford decision comes out, every similar case will need to be looked at through that new framework. But while people who support gun rights are happy about this, the states that oppose gun rights are already making plans. There are reports coming out that states like Hawaii and New York are thinking about changing their laws to try to make the case irrelevant. They might adjust or remove their restrictions just enough so they can argue the case no longer matters, hoping the Supreme Court will just dismiss it. This strategy isn't something new. In fact, New York used this exact approach a few years back. When the Supreme Court was about to hear a challenge against one of New York's gun transport laws, the state quickly changed that law, which technically made the case moot. The court dropped the case and New York managed to avoid a significant defeat. But that only pushed the problem down the road. The same issue came back later as the Bruin case, which turned out to be a landmark win for Second Amendment rights. So it's entirely possible that Hawaii and other states will attempt this same trick again. But the Supreme Court seems more ready for it this time around. This case will probably move forward no matter what minor changes the states make, especially considering the larger constitutional question that's at stake. The justices want to settle this issue completely and permanently. The pattern has become obvious. States keep passing laws that openly go against the court's earlier decisions, essentially daring the Supreme Court to do something about it. With this emergency order, the court is sending a signal that they are running out of patience with this behavior. What makes this development even more significant is the broader legal picture. Since the Bruin decision came down, lower courts have been divided about how to interpret the new history and tradition test for gun laws. This is the standard the Supreme Court created to figure out whether modern gun regulations are consistent with what the Second Amendment originally meant. Some courts have used that test properly and struck down laws that violate the Constitution. However, other courts have twisted it around, arguing that if they can find any historical comparison, no matter how weak or distant that comparison might be, then a modern restriction should be allowed to stand. This inconsistency has created confusion all across the country, and the Supreme Court knows it needs to step in and make the rules clear. Woolford v. Lopez gives them exactly the right opportunity to do that. If the court rules in favor of the plaintiffs, which many legal experts think they will, the decision could completely tear down these default bans and strengthen the principle that the Second Amendment isn't a lesser right compared to other constitutional rights. It would send a strong message that states can't play games with constitutional freedoms, that the right to defend yourself doesn't disappear when you cross a state line, and that nobody should need special permission to exercise a fundamental right. On the flip side, if the court upholds Hawaii's law, it could encourage states to pass even more far-reaching restrictions. This would effectively let states nullify the right to carry guns in public by using technical loopholes. That's exactly why this case is being watched so carefully, not just by attorneys, but by millions of Americans who care deeply about their rights. Freedom doesn't defend itself automatically. It takes constant attention, awareness, and a willingness to fight for what's right, even when it's not the popular position. This emergency order from the Supreme Court is a reminder that the Constitution still has meaning and that when things go too far, even the highest court will take action to protect it. This story is nowhere near finished, and whatever comes from this decision will impact every part of the country. The justices will hear arguments, review briefs, and ultimately issue a ruling that could redefine how Second Amendment cases are handled for decades to come. This could mark the beginning of a new era where constitutional rights are finally treated with the same respect as every other freedom in the Bill of Rights, and for states that have continued to defy those rulings, it could mark the end of their attempts to undermine them. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.